Konnichiwa. Welcome to Chocolate with Ed Garcia. The best part of Chocolate with Ed Garcia is Ed Garcia. No. The best part is chocolate. Chocolate, chocolate, chocolate. Today we have chocolate from Furuta chocolate. I have no idea what this is. Okay. Well, it looks like chocolate. Delicious. Okay. Welcome to Chocolate with Ed Garcia. Today's speech is speech 21, Indefiniteness. Specifically, we're going to talk about a SCOTUS case. SCOTUS is Supreme Court of the United States. Supreme Court of the United States. SCOTUS. Nautilus versus BioSig. This is a very famous case because Supreme Court Justice Ruth Bader Ginsburg, RBG, Ruth Bader Ginsburg, wrote a unanimous opinion, and it says that the claims must be reasonable. They must be reasonably clear. Okay? So, as you know, I'm a U.S. patent attorney. I'm a former patent examiner. This is not legal advice. And today is the 30th of May, 2021. Continuing. Here is a picture of Ruth Bader Ginsburg, very recent, just a few years ago, 2016, an official portrait. As you can see, she's very old. and she got even older. Last year, 2020, she died at age 87 years old. She kept working until she was 87 years old. As you know, United States federal judges have lifetime appointments. They can work for their whole life, or they can retire if they want to. So Ruth served on the Supreme Court many years, and here's a picture of her when she was younger. We should not forget, she was a young woman many years ago. She lived a full life. She had children, she was married. So here is the history of indefiniteness. I'm just going to provide this here for you as a list, as a reference. And it ends 2014 with Nautilus, this case. Back in the beginning, Old English property law talked about land. So when you sell land or buy land, it must be in writing, and it must be very clear, including the boundary, the edge of the land. What does the land include? What is the boundary? What is the scope of the land that you're selling or that you're buying? And in English common law, they talked about metes and bounds. You can describe the boundary of the land in various ways. You can describe it as metes, like meter, between 2 points. So here's some location, here's another location, and a line stretches, for example, from east to west 100 meters. Okay, that would be metes. Or bounds. What are bounds? Bounds are, well, boundary, such as a river. That's a very good boundary. Now, interestingly, rivers do change occasionally, but it's pretty rare. So, as you all know, the United States Constitution says to promote the progress of science and useful arts by securing for limited times to inventors the exclusive right to their discoveries. Okay? So U.S. patent law has its basis in the United States Constitution, the basic law of the whole land. Now, we had a large number of patent acts, laws specifically about patents, and the first one was 1790, relatively early, and it said specification containing a description of the thing or things invented or discovered, which shall be so particular as to distinguish the invention or discovery from other things before known or used. So particular as to distinguish. In other words, the written specification must make it clear what you're inventing, clear enough to distinguish over what other people have invented. The best way is to say, look, someone invented this tape dispenser, and I am changing it by, for example, putting a cutter on the edge of the tape dispenser. I put the cutter here, and maybe that's an invention, for example. Now, continuing, Thomas Jefferson was the first patent examiner. Yay for patent examiners! He was the first patent examiner. He was also the second vice president of the United States, and he was the third president of the United States. If you want to learn more about Thomas Jefferson, see my speech number 8 on YouTube, Chocolate with Ed Garcia. Here's an invention by Thomas Jefferson. This is his book stand that he invented, and it rotates. See this part here? This part rotates, and this part stays on top of the desk. And he can hold 1, 2, 3, 4, 5 books at the same time. And this is large enough where the books can open, and he can read the books and rotate and look at different books on the same subject at the same time. This is very similar to some of my friends have 3 computer monitors on their desk so they can look at 3 different documents at the same time. Well, Thomas Jefferson, he can look at 5. Maybe not at the same time, but maybe 1, 2, 3 at the same time. Yeah, and he can rotate it. It's very nice. So, Second Patent Act, 1870, very similar. Particularly point out and distinctly claim. Particular and distinct. What about the Third Patent Act? Particularly pointing out and distinctively claiming. Pretty much the same words, right? Very little change. And the Fourth Patent Act, which is the one that we are using right now in 2021. This was passed in 2011, relatively recently, and what does it say? Claims particularly pointing out and distinctly claiming. So every time the United States government decides to change the law, they don't change it very much with respect to this portion, okay? The portion about claiming. The claims particularly point out and distinctly claim. Well, what does that mean? We're going to discuss that. Well, in 1996, Markman versus Westview, Supreme Court case, said, it has long been understood that a patent must describe the exact scope of an invention and its manufacture. Exact scope. Scope is similar to boundary. Okay, what does it cover? What is within the boundary? When you look in a telescope, what do you see? Right? What's in your scope? So, slightly different words though, right? Exact scope. What happened to the previous words? Particular and distinct. Well, exact, slightly different. This is maybe a little bit stronger, a little bit tighter. Or, in 2002, Festo says, a patent monopoly is a property right, and like any property, and they're talking about land property here, any property right, its boundaries should be clear. Okay, clear. Exact, clear. What about the next case? 2005 Datamize. It's a little bit confusing, I have to say. So, a claim is indefinite when it is not amenable to construction. Notice the double negative here. Indefinite, so it's not definite, it's not a good claim when it is not amenable to construction. Okay, so let's get rid of the indefinite and let's get rid of the not. Let me say it again without the double negatives. A claim is definite, it's good, when it is amenable to construction. What does that mean? That means we can construct it, we can understand it, we can figure out what it means. Similarly, they use another set of words here. The claim is indefinite when it is insolubly ambiguous. Again, the double negative. Let me read it without the double negative. Lawyers often use double negatives. I don't like it. So let's do it again. A claim is definite when it is solubly ambiguous. What does that mean? Solubly means you can solve the problem. Ambiguous means you're not sure. So what does that mean? A claim is definite, a claim is good, even if it's ambiguous, meaning you're not sure. Is it A or B? How do I interpret this? I'm not sure, A or B, but I can solve the problem. I think about it and I can figure out that really it's B. Okay? So it's acceptable, it's definite, it meets the statutory requirements if it can be solved. So it can be a little bit ambiguous as long as I can find a solution. I can fix it. Well, this is a little bit different than clear, and it's a little bit different than exact, right? So we're kind of going in different directions here. And this is when the Supreme Court likes to step in. So the Supreme Court steps in and says, we need to figure this out. So we have Nautilus, and we have our very famous RBG, Ruth Bader Ginsburg, giving this opinion. A claim is indefinite, again the negative, if its claims read in the light of the specification and the prosecution history fail to inform with reasonable certainty those skilled in the art about the scope, the boundary of the invention. So again, we have the double negative. Indefinite if it fails. Why do lawyers always use double negative? Let's look at it differently. Let's look at it double positive. Okay? A claim is definite, forget the end. A claim is definite when it informs with reasonable certainty. Okay? Reasonable certainty. So one of the previous cases said exact. Well, that's maybe a little bit too much. Another case said solubly ambiguous. So it's ambiguous, but we can solve it. That's also okay. And Nautilus kind of goes in the middle. Nautilus says reasonable certainty. Okay? Reasonable. What's reasonable? What's certainty? Well, very difficult to define, but always remember who applies the law. And the answer is a very short woman who's very old, and her name is Ruth Bader Ginsburg. Okay, she's about this tall, and she's very old, and she decided this case and wrote the opinion. All right? An engineer did not make this decision about reasonable certainty. This decision was made by an 87-year-old woman with a degree in government, okay, Bachelor of Art in Government. All right, so again, let me translate this for you into easier language. A claim is good if it's reasonably clear, okay? Claim must be reasonably clear. This is my language. No double negatives, nice and simple. Has to be reasonably clear. In the eye of Ruth Bader Ginsburg, a very small, very old woman with a degree in government. Okay? Continuing, as we said, the most recent law says particularly pointing out and distinctly claiming. So this means reasonably clear. What does that mean? That means that Ruth Bader Ginsburg must understand it. Okay, that's what it means. So here's a summary of the language. I'm going to just say the language as it changes very slightly over the years, okay? Metes and bounds. Limited times to inventors the exclusive right to their discoveries. Description shall be so particular as to distinguish the invention. Particularly point out and distinctly claim the part. One or more claims, particularly pointing out and distinctly claiming the subject matter. Claims particularly point out and distinctly claim. Okay, so particular and distinct. And then we have Markman, we have Festo, we have Datamize, and let's just skip to Nautilus. Nautilus, inform with reasonable certainty. Okay? Reasonable certainty. Inform with reasonable certainty those skilled in the art about the scope of the invention. Okay? Those skilled in the art. But who decides? Who decides? And the answer is Ruth Bader Ginsburg decides. Continuing. So here we have some definitions. Let's just read one of them. Reasonable. Reasonable says fair and sensible, appropriate, moderate. Well, what do those words mean? And let me tell you exactly what they mean. Those words, all of these words mean Ruth Bader Ginsburg will decide. With a bachelor's in government, okay? Remember, that's your audience. Continuing. So here's Ruth again. When she was young, and when she was a little bit older, a little bit smarter, and a Supreme Court justice. She was the second woman appointed to the Supreme Court. The first was Sandra O'Connor. She was the second woman ever appointed to the United States Supreme Court. Quite an honor. An amazing woman. She spent most of her law career before becoming a judge working on women's rights things, helping women. So she's done many good things in her life. And as I said, last year she passed away while serving as a Supreme Court justice. So here's Ruth. She was Supreme Court Justice 1993 to 2020. Now, I became an attorney in 1998. So Ruth, I've been reading opinions, Supreme Court decisions written by Ruth Bader Ginsburg for Justice Ginsburg, to be polite, my entire legal career. Okay, so I feel like she's my friend. And of course, she wrote the Nautilus decision in 2014 at age 81. 81. Born in 1933. She got her Bachelor of Science in Government 1954. Before I was born, she had her degree from Cornell. She entered Harvard, one of only 9 women. She entered Harvard, one of only 9 women in a class of 500. And in 1959, she graduated from Columbia, tied for first place. She transferred to Columbia because she was married to her husband, who was in the military, and he was assigned to moved to a different city, and she followed him. Of course, nowadays, many women would not follow, but she did follow. In fact, they had a small child at that time. I forgot what age, maybe 3 or 4 years old. She had a baby when she entered law school. So she's a very, very busy woman. A very busy woman. Continuing, she died last year from metastatic pancreatic cancer, and this was her 4th cancer. So despite having 3 previous cancers and the 4th cancer, she did not resign from her job as Supreme Court Justice. As I said, Supreme Court justices have lifetime appointments. They can serve for their entire life until they die. Now, previously in old American history, a lifetime was perhaps 50 years old. But now we see that justices can live an extremely long time, 87 years old in the case of Justice Ginsburg. And that's a long time to be on the court. So she was a Supreme Court justice for how many years? 1993 until 2020. So 27 years as Supreme Court justice. That may be too long. We, the United States, should consider a time limit for judges, perhaps 20 years and perhaps maximum age of 80, because let's be serious, at age 87 she was having problems, okay, including her 4th cancer. Resources and links. I have 20 speeches on the YouTube. Just type in "Chocolate with Ed Garcia." And here's a song by Elton John, Tiny Dancer. So please, play this song by Elton John and think in your mind of Ruth Bader Ginsburg. She's an amazing woman, and she is a tiny dancer. We're going to do a bonsai for Justice Ginsburg. Let's go back to her picture. She's my friend. I've read her opinions for more than 20 years. She's my friend. And I am very sad that she's died. We're going to do a bonsai for her. 3 bonsais for Justice Ginsburg. Bonsai! 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 This is the end of Chocolate with Ed Garcia, Speech 21, Indefiniteness, and RBG, Ruth Bader Ginsburg. And this, in summary, the claim must be reasonably clear, and it will be interpreted by a judge, such as a very small, very old Justice Ginsburg. This was the best speech ever. The best speech ever. Yes, it was the best speech ever. And we're not even finished. We still have Mount Fuji. Nihonbashi Bridge in Edo. Here we have, of course, Mount Fuji and a river and a bridge. And look at all these people. All these people are going to the market. They're very busy. They're very happy. It's a beautiful day. And if we zoom in a little bit, we can see they're carrying things. Here's many things on a cart. Here's the wheel. And here's 2 hands. This person is very short, like Ruth Bader Ginsburg, and they're holding their things, whatever it is, taking it to market. And this is also interesting. Here's a woman talking to her friend here, and they're standing in the middle of the bridge talking, and all these people are trying to get them out of the way. Go, get out of the way. We want to get to work. We want to sell things and make money. But she's very happy. She sees her friend and she's talking to him. The end of Chocolate with Ed Garcia. Thank you very much. Nihon ga daisuki desu. Arigatou gozaimasu. Sayonara.